manufacturers, policymakers, visitors, members of the media, interested persons, distinguished guests, good afternoon all. And if I might say, a virtual welcome to Trinidad and Tobago, and indeed to the Trinidad and Tobago Fair Trading Commission. This conference is about investment. It is about investment in manufacturing, in distribution, in export, in import, and all kinds of businesses, all dimensions of businesses along the various value chains. In other words, this conference is about business and growing businesses. These are all activities we recognize as fostering development, social development and economic development, or if you rather, economic development and then social development. I wish you to know that the Trinidad and Tobago Fair Trade Commission supports development, supports sustainable development. That has come to mean just more than just doing business, but it has come to mean much wider or have much wider dimensions in which business will take place. We at the TTFTC support business growth that is respectful of people, that is respectful of the environment, and which follows key principles of what we call fair competition. And those principles are enshrined indeed in the Fair Trade or Antitrust Act, or whatever you call them, in over 130 countries all over the world. So on the other side, we do not support unfair business practices. And again, we find that amongst fair trade commissions and amongst those who have been practicing fair trade for decades and even centuries, they have defined, as we have defined, what are unfair business practices. So practices which are anti-competitive, as defined by this country's Fair Trading Act, are those that we advise businesses to stay away from. We support business development that involves monopolies, trade agreements, mergers, and whatever else or whatever form business development and growth takes. What we do not support are practices under those headings which cause harm to other businesses, especially small and medium-sized businesses, but not exclusively, as well as harm to consumers. We do not support practices which cause such harm. We are very much aware of the times that we live in, like I'm sure you are. The impact of COVID-19 globally and on Trinidad and Tobago has in fact been devastating. So we recognize that we now live in difficult times. And what we are doing is trying to understand what these challenges mean for business, what being safe means, what protecting livelihood means, what protecting health means. We are trying to understand that growing the economy while we protect ourselves really is the challenge that is facing Trinidad and Tobago, as it is your countries and countries all over the world. We are taking the time to understand that there is need for mergers, etc., and that there is evolving new business models in this time. Businesses are struggling to find new technologies, new ways of doing business, greater use of the technologies that are available to survive and to grow out of this unprecedented environment. The Trinidad and Tobago Fair Trading Commission is committed to discussing with you these new developments and how companies can remain within the law while fostering expansion, while fostering growth, and while fostering development. We welcome our own manufacturers in Trinidad and Tobago, and indeed manufacturers that we understand are listening to us, are seeing us from all over the world. We enjoy that, we support that, we promote that. With these few words, I open our session and would pass you on to our Executive Director, Mr. Bevan Narayan Singh. I thank you for being present in our session, for listening to me, and now to our ED, Mr. Narayan Singh. And I stand ready, like Mr. Narayan Singh would be at the end of his session, to listening to your comments and in taking your questions that you might have. I now pass you on to Mr. Narayan Singh.
Okay. And thank you very much, Chairman, and good afternoon to everyone. We as a commission would like to thank everyone here for being present. We know everybody has busy schedules. However, I think that a session like this is very important, definitely because of the type of business or activities that you are involved in. So it's good that you get a better understanding of how competition is expected to operate in the marketplace, especially with a piece of legislation that was basically recently proclaimed. So what I think we should, and again, thanks for the TTMA for giving us the opportunity to discuss the work of the commission. I think what is very important here, though, is that we want to hear from you, right? All the participants who are here, we want to hear from you. If you have any questions you want us to answer and to address, both Dr. Ramkisoon and myself will try to address it to the best of our ability, because at the end of the day, what we want a fair and competitive market that benefits everyone, whether it be small or large, because competition is the way to go, right? We in Trinidad and Tobago, through various government policies, have embraced the principles of a free market economy. This entails certain policies as well as legislation, such as the Fair Trading Act. So basically, this is an opportunity for you to hear from us, hear about the Fair Trading Act, how this could boost competition, Trinidad and Tobago's competitiveness, and then we invite some discussions. So well, based on the time frame we have had here, we've been given 2 hours to discuss certain pertinent issues. Now, I don't expect that we will go into my presentation is definitely not going to go into 2 hours. So the idea then is for us to give you an outline of the work of the commission, and then we would invite questions, and we will try to address these questions again to the best of our ability. What I would also want is that persons who are registering to please, who have registered, to please indicate to the TTMA your details, And so we could be able to then share some of our information as well as certain parts of the presentation as well too, so that you all will get a better understanding of what we have discussed this afternoon. So basically, this presentation is going into certain areas that I think is very important. We are going to be talking about the Fair Trading Commission. The chair had given you described us briefly, and I will just go into a little more detail who we are and what we do. Again, our role in the overall context of policy making and policy implementation. Then we will go into the key provisions of the Fair Trading Act, a piece of legislation that was fully proclaimed in February of 2020. Then we will also be advising on how to ensure compliance with the Act. Then we will then be discussing how to contact the Commission. So basically, this is basically what the flyer had indicated. And these are very important so that you all would know what we are about, and most importantly, how you can find out more about us and things like that. So about us, well, basically, we are an independent commission, right? We have been developed. And by the way, some of you all may have listened to presentations before from us, but I mean, for those who may not have known about us, and especially some who are new, especially foreign persons who are from abroad, who would be now attending the Trade and Investment Convention. So basically, who we are is that we are an independent body. We are established pursuant to the Fair Trading Act. Our goals are to promote, protect, and maintain competition in Trinidad and Tobago. And how do we do this? Well, this is based on the provision of the legislation. We do this by preventing anti-competitive conduct, as well as taking action against certain anti-competitive practices, such as abuse of dominance, restraint of trade, and unfair and deceptive trade practices. We also have a role, which is like what we're doing here now, diffusing and publishing information and sharing information about competition and its benefits. And we also have a role to advise government on general issues affecting competition. Just to reiterate, we aren't new to this in the sense that Trinidad and Tobago, because there are 130 such agencies all over the world that are functioning globally. Persons who are familiar with the CARICOM region, there are also commissions in Jamaica, Barbados, and Guyana. So this is a policy area that has been really addressed and been implemented by a number of countries because they see the benefits of a more competitive market. And by implication, this would mean having an agency such as us to help enforce the relevant competition legislation so that there could be the maintaining and promotion and protection of competition. And what do we mean by competition? Well, competition is really, how you define it, is really a situation where there are hopefully many sellers and many or buyers, so every seller trying to increase his profits by offering, basically you're competing on your price, your quality, and your service. So the combination of that would make your product be more it would be such that like someone would want to purchase your products and everything like that. So that is what we're looking at, a competitive market where various factors come into play, and then the decisions are made by the consumer how best to spend their scarce resources. And that means that there's need for an effective framework in place to ensure that this happens. Now, this is very important in the context of Trinidad and Tobago, as well as other jurisdictions, because this is a part of the ways to enhance the competitiveness of the country, to improve the investment climate, and also to promote an enabling environment for growth and development. So, as Chairman had indicated, this is even more important during a period where there has been economic slowdown caused by, generally the economic situation in Trinidad and Tobago, which of course has been exacerbated by COVID-19 as well too. So this means that we need to really compete properly, compete effectively, because the key, of course, is for us to become more globally competitive for our goods and services. Now, in the context of government policy, I think it is very important for persons here too, because who are looking to invest in Trinidad and Tobago, who even Trinidad and who are even locals who want to do certain investment activity as well too, who want to do manufacturing. You have to understand the context of a commission such as this in terms of the broader perspective. Now, government has a vision 2030 vision, particularly with respect to trade performance and business facilitation. And in particular, out of this 2030 vision, there's theme 4, which was really the area would be building globally competitive businesses. That's the key, to build globally competitive businesses. Now, government has a number of policies that they wish to implement, but part of this process is that in order to be globally competitive, you need to also be competitive locally. And this means that you need to have commissions such as this to encourage and promote competition. Also, by us having a competition regime in place, this has been, again, basically empirical evidence from around the world is clear that having such a regime in place makes the country more investment friendly, at least to foreign investors, because there's a system to protect and promote competition, which at the same token makes the environment more conducive to entrepreneurship and innovation. So that in itself makes us a more attractive destination for investment and trade. Having a properly functioning Fair Trading Act, and by implication, a properly functioning Fair Trading Commission. So going further into the National Development Strategy, this legislation, if properly enforced, is expected to support various policies in the areas of business facilitation, export promotion, trade development, as well as general business development. Because the idea is that this is a part of the process to ensure fair trade and discourage businesses from engaging in anti-competitive business practices. Now, I will go into some detail on what these entail. If some of you all have been the victims of these types of conducts, please contact us so that we could investigate or discuss further if indeed this is something that we could assist with. In terms of the Fair Trading Act, the Act really is designed to not only protect the economy, but to protect consumers and businesses from anti-competitive behavior, because we are trying to promote competition, innovation, and greater choice. This legislation was first passed in Parliament in 2006, but for various reasons was only fully proclaimed in February of 2020. And I'd like to take the opportunity to thank the Trinidad and Tobago Manufacturers Association. When this legislation did come into force in 2020, we immediately was given the opportunity to make a presentation about the provisions of the legislation to some of its membership, because it was also a recognition by not only the TTMA, but also various chambers of commerce in Trinidad and Tobago, as well as other business associations, about the importance and the need to have a competitive structure in place. So this is very important as we move forward to have this type of legislation and also to have a relationship with stakeholders such as the TTMA and other business associations. Just to also mention that this act is of general application, while there may be certain sectors where the act wouldn't apply to. This is because there are already sector regulators that deal with this, with those competition issues. As an example, for the banking industry, there would be the Central Bank and the Ministry of Finance. We would not deal with that. We also wouldn't deal with the telecom sector, because that will be dealt with by the Telecommunications Authority of Trinidad and Tobago, as well as the securities industry, because that will be dealt with by the Securities and Exchange Commission. But basically, everything else will fall under the jurisdiction of this commission. Just to also mention that state-owned entities who are involved in commercial activity will also fall under the purview of the legislation and by implication, the regulation of the Fair Trading Commission. In terms of anti-competitive agreements, now, there are many examples of this, but basically these relate to agreements between enterprises as well as certain practices, as well as decisions of business associations, if necessary, which are likely to substantially lessen competition. So what does that mean? Is that these agreements affect pricing, affect choice, and affects the quality of goods and services that are provided in the market. Now, this can take many different forms, some of which you all would be familiar with, but I will just elaborate on some of them. The first would be price fixing. This would be a situation where there's an agreement between competitors with regard to a common price to charge for consumers. This also includes like such things like agreements to not to have discounts, agreements to coordinate in terms of when you're going to increase prices, or whatever formula you're going to use to determine prices. The result would be, of course, the consumer is paying significantly more than what they would be paying for in normal competitive situations. Also, other anti-competitive agreements would be agreements between competitors to share markets. As an example, an agreement between an entity, if two entities with market power agrees, one says, I will take in the context of Trinidad and Tobago, the Port of Spain market, or let's say one takes Trinidad and one takes Tobago. Like these kind of formal types of agreements are anti-competitive agreements. You can't do that. There's also any agreements between groups of entities to boycott or make it difficult for market entry for other entities, for a new entity. That in itself is anti-competitive agreement, an anti-competitive agreement as well. There's also situations of bid rigging, that is with respect to the area of procurement, where entities collude in terms of the price that they would be tendering for services, or they agree among themselves who is going to be getting contracts. So these are violations of the Fair Trading Act. And once these are proven to exist, they are actually what we call strict liability offenses under the Fair Trading Act. So these are some of the areas where you need to be very careful in terms of if you engage in conduct such as this. Other types of agreements that may be possibly anti-competitive would be agreements between entities at various stages of the value chain. We call that vertical agreements. This was, for instance, between a retailer and a wholesaler. And sometimes, now these aren't automatically anti-competitive, but of course we will need to look clearly and to see what's the effect on the market. For instance, exclusive distribution type of agreement, agreements between a wholesaler and a reseller that the seller will not will not sell below a certain price. Those things, even at various stages of the value chain, would be a violation of the Fair Trading Act. Situations where a manufacturer may be forcing a retailer to take the manufacturer's complete range of products, when in fact the retailer might just want one or two items. But we call that full line forcing. If there's any evidence of that, this could potentially also be anti-competitive. Of course, if a manufacturer also specifies the amount of a product that a retailer must sell, or there's like exclusive types of arrangements, quantity forcing kind of arrangements, these are also not allowed if the effect of this is anti-competitive. Now, we understand certain arrangements at the various areas of the value chain are indeed important, but at the same time, the efficiencies of these arrangements, such as improving product standards and quality, cannot be at the expense of affecting the general competitive structure of the marketplace. So when we do that, when we look at these type of agreements between vertical competitors, we will evaluate the positive and negative effects of this practice and then make a determination, in fact, whether that is indeed anti-competitive. One of the areas where we also have a very important role to play is in the area of abuse of dominance, or under the legislation, abuse of monopoly power. A situation like this arises where a firm in a market has the ability to raise prices profitably above what is we consider to be the competitive level for a sustained period of time. Now, this has effects on general productivity and general efficiency as well too. Under the Act, an enterprise would be considered as having monopoly power if it controls 40% of a market. Just to reiterate, we aren't against an entity having monopoly power, right? The issue is if they are abusing that power. If they are using that kind of power to force other entities to impose uncompetitive pricing, and also to make it difficult for new entities to enter into the market as well. And this is basically because general economic principles are based on the fact that companies who have, a large proportion of their business have a special responsibility not to engage in anti-competitive behavior and abusive behavior, because this in itself affects not only the structure of the market, but it also weakens competition, and it adversely affects price, output, and innovation. So that is key. We have to ensure that firms who are in a dominant position do not prevent competitors from competing effectively. So what I would want when you, if you have to ask any questions, is that you all should think about it among yourselves. Can you think of any firm that is dominant in Trinidad and Tobago? And by considering that, you should look at whether there's the ability to raise prices, basically without consideration to how competitors or customers would react. In fact, you have the power to do that. You also look at whether they have market share. And by implication, you also look at the nature of the industry too. Because certain industries, you can have market power, but the fact of the matter is, mightn't be able to sustain that market power if there's if entry into the particular market is not that difficult. And again, as we have to reiterate, we are not against an entity being dominant. What is bad is if there's abuse of dominance, and that is the engaging of conduct that lessens competition. So the Act lays out certain practices that would amount to abuse of dominance. Just to mention a few, it would be any actions that eliminates or removes any person from a market by imposing unfair purchase or selling prices or other anti-competitive practices, directly or imposing unfair purchase, limiting the production of goods or services to the prejudice of consumers, and really making the conclusion of agreements subject to really extraneous circumstances and situations that really would not be ideal for a competitive market. So these are some of the things that we would have to look at and make a determination. Thirdly, so I mentioned the anti-competitive practices, as well as the situations of abuse of monopoly power. Under the legislation, and this is important for persons who are coming and wishing to invest in a large scale in Trinidad and Tobago, whether that be through the acquisition of companies already in the market. Under this Act, we have what we call merger review powers, merger control powers. So this would be a situation where two enterprises who were previously distinct are no longer so, whether it be through purchase, acquisition, amalgamation, a joint venture, or any other means where there's now one combined entity. You may call it whatever hunting, whatever words, but mergers that is what a merger really would be for the purposes of the Fair Trading Act. Now, we understand, especially during the times of COVID, that firms do merge for a number of reasons. For instance, for efficiency reasons, to take advantage of the advantage that where um, they might get from the target company, whether it be some specialization or skill that they have to offer. It's also an opportunity for a firm, like for instance, a foreign firm who's acquiring a local company, whether they wish to enter into a new market or even diversify an existing product base. So these, we understand the need for the mergers as well too. But of course, there may be a situation where mergers will be eliminating or preventing competition in the market. So in such situations, we would obviously have to look at the pro and anti-competitive aspects of a merger, because of a proposed merger, because we have what you call um, ex ante control, meaning that the merger has to be approved first by the commission before that combined entity can do business in Trinidad and Tobago as the new merged entity. And in terms of how and when our jurisdiction kicks in, this happens when the assets of entities who are merging exceed 50 million Trinidad and Tobago dollars, and at least one of the entities or enterprises carries on or intends to carry on business in Trinidad and Tobago. So once entities together exceed $50 million in terms of their combined assets, and the intention is for them to do business in Trinidad and Tobago, it is a prerequisite that they get the approval of the Trinidad and Tobago Fair Trading Commission. Because if this approval is not received and they go ahead with their transaction, the commission does in fact have the power to investigate, and this could lead to issues because the courts, because our authority would be then to go to the courts, and the court could then make an order to prohibit the acquisition that just took place, and even get an order for divestment or fines or other appropriate remedies. So just to reiterate, if an entity is coming into the market and they wish to acquire or combine itself with another entity, and the combined assets exceed $50 million, and they intend to carry on business in Trinidad and Tobago, they will be required to contact and get the approval of the Fair Trading Commission. In that light, we have developed merger guidelines that we share with parties who intend to merge, and these guidelines would be posted very soon on our social media pages as well as our website, the draft guidelines, for public comment. So just to mention, when we are doing these types of work with respect to mergers, we will be very forward looking in our analysis, and our issue would be ready to ensure that it doesn't substantially lessen competition. And and so that is the key, is whether this activity will have or likely have that effect if approved. So in terms of that, now we have gone through some of the key provisions in the act and everything like that. Now, the persons who are here, at least based on the names I'm seeing, come from a wide plethora of sectors, industries, backgrounds. And what I would tell you is that there are various areas where you would need to possibly get in contact with the commission. First being the obvious is if your company or client is a victim of infringements under the Fair Trading Act. In such a situation, you would have to formally make a complaint to the commission. The commission would then, and we intend to be a very fair and transparent organization, would examine the complaint, and then, of course, we will give some guidelines on how you could make such a complaint. Bearing in mind that the complaint has to, be the area that is covered under the jurisdiction of the commission under the Fair Trading Act. So we will then have to examine the complaint and see whether it has merits. Another area where you is if the shoe is on the other foot is whether your company has been accused of competition law infringement. Now, we adhere to proper administrative principles, right to a fair hearing, nobody presumption of innocence before guilt, but it may mean that such entities that have been accused of anti-competitive practices would need to come before the commission um, and hear and really respond to the commission and what the commission's allegations after, of course, we do our after we examine the complaint that may have been lodged against the entity and see whether it has merits, and you would have to explain if that conduct the justify your conduct, and I mean even argue that it's not anti-competitive. Another way where you could be involved with the commission is when if and when the entity that you work for or own intends to merge with another entity. If that is done, you will have to formally make a application to the commission, and the commission will then will get in contact with you, and we will ensure that everything is in order with what is required under the merger guidelines and the Fair Trading Act, and hopefully we will then make a decision within 1 month of the application. So I mentioned how you could get involved in in terms of the work of the commission. It's also important to bear in mind the powers of the Trinidad and Tobago Fair Trading Commission. Now, all, of course, being established under um, uh, a legislation, the our powers are clearly will be clearly set out in the Fair Trading Act. And what is important, I mean, I mentioned already how we have a role to promote and maintain competition, but we also have a role to protect competition. And how do we do that? We protect competition by potentially taking to court any business or individual who has been found guilty of anti-competitive practices and after meeting with the commission has failed to take corrective measures as so instructed. So indeed, we can take the entity enterprises to court that are guilty of anti-competitive practices, whether it be an abuse of a dominant position, whether it be a cartel type arrangement, whether it be bid rigging, and whether even if it's and also even if you do a merger that would have fallen under the commission's jurisdiction without our approval, because that would be considered anti-competitive as well. So the courts would have a lot of power with respect to that. Again, it's set out in the Fair Trading Act. And some of the enforcement powers the High Court would have. Of course, appeals from that could go to the Privy Council, to the Court of Appeal, and even up to the Privy Council in Trinidad and Tobago. Courts could prohibit an agreement from being carried out. They can order agreements to be terminated or modified. They could even potentially divest and break up a monopoly type situation. The courts could even declare certain types of arrangements and agreements that entities have entered into as void, with there being consequences for that. And also, courts could impose penalties against proven cases of anti-competitive behavior. Now, depending on the conduct of the entity that is guilty of the anti-competitive behavior, they can face fines of up to 10% of their global turnover. So if an entity sells $100 million around the world and is guilty of anti-competitive practices in Trinidad and Tobago, the court, depending on how egregious the conduct is and the nature of the activity, could fine an entity up to 10% of its global turnover. Now, what is important about that too for many persons here who may also be parts of small enterprises and who are now starting out, if indeed you all have been the victim of anti-competitive conduct or practices in your mind, and you bring it to the commission, and then the commission um, finds that this entity, the entity that the complaint was launched against, is really guilty of anti-competitive activity and goes through the proper court process, not only would there be fines against the entity, but the complainant, such as, let's say, one of you all who made the complaint, once you can quantify the losses that you may have suffered as a direct result of the anti-competitive behavior, whether you couldn't enter a market, whether you couldn't sell at the prices you wanted to sell, whether the anti-competitive practices forced you out of the market, the court could potentially award private damages as well too. So please bear that in mind. So even if the entity is fine, that might not be the end of it. If indeed you privately would have suffered as a result of that, there could be private action as well as a result of that. But what I would say to entities who may be committing practices that may be considered anti-competitive is that you also you don't you shouldn't even look at the issue of fines as well too. Um, what empirical evidence around the world has really seen and shown is that it is not it is not the business savvy thing, I would say, to be the subject of an antitrust or anti-competitive type of investigation by a commission such as this. Because not only are the investigations lengthy and it means loss of management time on behalf of the entities in question, there's also the issue of reputational damage as well too. Some entities, once they're accused, especially in a small market like Trinidad and Tobago, of anti-competitive activity, the damage to their reputation is potentially tremendous, and how they were looked at, of course, among their entities as well too. I'll just give you an example: the TTMA. Now, I have no aspersions on any membership of the TTMA or anyone who's a part of the TTMA, but if indeed there is a case against a TTMA member for anti-competitive practices, I would tell you unequivocally, at least 95% of the TTMA's membership would not have been engaging in anti-competitive activity. So that one entity, so if you were that in itself, that reputational damage among your peers, it might be irrecoverable. So, I mean, that's one of the things to be quite careful about, especially in a market where many and most entities try to compete on their merits. In terms of procedures and everything, I mean, I did mention that earlier, but just to reiterate that, is that the procedure starts whether by a complaint that is made by whether it be a customer, consumer, or competitor, for whatever the practices were, whatever anti-competitive practices. We could also do a complaint of our own initiative. This has happened in other jurisdictions as well, because a big part of the work of commissions such as this is market monitoring too. So we monitor various aspects of a market, and if indeed we, in our own volition and our own research, find that certain activities are anti-competitive, we can in fact investigate entities in the market as well. We also deal with the cross-border aspect of that too, because there's also a CARICOM competition commission that deals with competition regionally wide, and they could contact us as well too in the event that this has to, such situations do happen as well too. So these are some of the things that we also have to do, and basically when we do our analysis, rest assured we are committed to be a transparent and accountable organization who is fair to all parties. So when we do our analysis and everything, it will be based on sound legal and economic principles. This means there will be considerable market analysis and the collection of evidence. We have various means of the legislation to do that. We probably call on the legislation dawn rates. It doesn't mean you're going to do the thing at 4 o'clock in the morning, but basically if you can get an order from the court to go into various premises and get relevant material with the assistance, of course, of the Trinidad and Tobago Police Service, if necessary. That would assist us in the investigation. Of course, we have a commitment to return the material that is taken within a stipulated time frame. So, as I said, after we get this, and eventually, if the entity does not um, adhere to whatever orders we do make, it is clear that it would then go to court, and the court could make some of the rulings that I previously mentioned. And of course, decisions of the court are subject to appeal. So, in terms of making a complaint, as I said, any party who is affected by or perceived to be affected by anti-competitive conduct or has knowledge of such activity, and this was important, the flyer also mentioned that, is that you are actively encouraged to make a complaint to us. When we do that, we will then first we will determine whether the allegation is valid, and if it indeed is could amount to a breach of the Fair Trading Act, and then after that we can then do our formal inquiry. But what I would say to persons who wish to launch a complaint, you please provide as much facts as you can as possible about this alleged activity, because of course we have to make sure that it does fall within not only the jurisdiction of the commission, but it would amount to anti-competitive practice or activity, or an abuse of dominance or anything like that for the purposes of the Fair Trading Act. Please also rest assured that any information that is submitted to us will be kept with the highest of confidentiality. Also note, it should be noted, for even if employees of entities that they feel have been guilty of anti-competitive activity, the whistleblower legislation that is supposed to be coming in very soon would protect such a complainant as well, meaning that they will have to be treated with the utmost confidentiality. Of course, in the complaint, please provide as particulars about the events that gave rise to the complaint, the business conduct that you have observed and considered to be anti-competitive, and basically whatever additional information and supporting documents to help the commission do its job. Now, the commission will still, of course, have to be transparent and do its own investigations as well to ensure that indeed the activity alleged is anti-competitive. But of course, the key is to, as much information as could be provided would be greatly appreciated. Right? Of course, any documentation that is in your possession directly connected to the issues, of course, please provide us. Also, please, in the complaint, set out how you believe that this alleged infringement or conduct complained of has affected you, and also what kind of remedy or interview you think the commission can help with, to help this grievance, this alleged grievance, and what kind of intervention that you're looking at. Right? Again, all information provided will be confidential and will be acknowledged by the commission. For entities who wish to conduct a merger, as I said, we have merger guidelines, but we also have a merger application form that we will provide to any entities who contact us, and we will and that will give you all really a good guidance in terms of what we would be looking for if indeed we want to consider and approve this merger. Right? We will have to, of course, when considering the merger, and this is clearly set out in the Fair Trading Act, we have to ensure that the merger would not, basically the benefits of the merger exceeds any deleterious effect that it may have on competition. We also have to look at the potential effects of this merger on the economy and on consumers on a whole. So it's really a holistic approach, because it's very broad and very wide in terms of the work of the Fair Trading Commission in that respect. Of course, if we, after examining the transaction, is of the view that the merger should not be approved or not, or at least should not be approved in its present form, we will advise the emergent parties so forthwith, and and even advise them what may be needed to do in order to get the approval of the commission with respect to that merger. What I would also hopefully get across to everyone here, many of whom are part of various business groups, various business entities. Sometimes you do work together with other entities. Now, this legislation is very broad. This legislation can cover a lot of certain situations. So I would just advise certain things to entities to protect yourselves and not be subject to potential investigations or violations of the Fair Trading Act, even if it's unwittingly. Um, Please do not discuss prices with your competitors. Pricing should be an independent decision. Of course, you can look at what other your competitors are pricing, but the area there cannot be and there should not be formal discussion with respect to that. Your pricing will have to be determined on what you think is the right price for your entity in the market and to preserve your business. And that should be an independent decision. Of course, don't also agree with competitors to boycott certain suppliers or customers. That group boycotts is an offense on the legislation. Also, don't agree with competitors to restrict or increase levels of production. That should be an independent decision based on market factors and the present economic situation that you all will face. Don't agree to share markets, and generally continue to deal as best as possible and as fairly as possible with your customers and suppliers, and ensure that you are complying with the law and remain alert to any types of agreements also in the market that may be taking place among your competitors. And for instance, if there's unexplained price changes, unjustifiable price changes, if that is happening indeed, that may be a sign of anti-competitive practices. Please, in situations like this, get involved and contact the commission. Of course, if indeed you are guilty of wrongdoing, please report it immediately, whether you have a legal counsel for a large organization or directly to the commission. This has an effect in terms of potential damages. If basically, if entities own up to their practices and everything, and they make a commitment to change these practices, this would have a major effect on any penalties that may potentially be imposed. Because, as I said, it's 10% of global turnover the courts could theoretically award, but this will depend on how egregious and basically how remorseful an entity is with respect to their anti-competitive business practices.
Mr. Narayan Singh,
Yes.
I want to ask you to take 2 more minutes to wrap up. Unfortunately, I cannot just slip a note to you.
Yeah.
And I think our audience would understand that. We want to give them a chance to ask some questions.
Mm-hmm.
So if you can wrap up in maybe 2 minutes so that we can then take their questions, comments. We have a number of them already sent to us.
Yeah, but I mean, we have until 4:30, so it's not going to be very long again. So basically, I just want to give you all an idea of the work of the commission as we move forward. And there are various sectors that we intend to be involved. As I said, we mentioned these sectors that under legislation that we would not be involved in. But there are also a number of sectors that we will be involved in, some of which have been already identified in the chat. And we will, when the questions do come, we will try to address them. And again, just to mention again, we will be acting at all times as an accountable, transparent, consistent, fair organization. And of course, be very objectively gather as much information, and any decisions or analysis that is done will be firmly grounded on sound legal and economic principles. Just to also mention, that we are quite aware of the situation with COVID-19. There are situations where there is going to be certain cooperative and collaborative efforts But of course, while we recognize the need to coordinate, especially in terms of to alleviate the shortages of essential goods or services, we will still at the same time hold accountable individuals and businesses who are using this as an opportunity to subvert competition, where there will be situations of increased pricing that may be evident of anti-competitive arrangements and abuse of dominance. Also, we reduce quality situations. This is very important because at the end of the day, we are also quite flexible under the Fair Trading Act to address these situations. And just to also mention, we are actually part of efforts by the Ministry of Trade and Industry in the area of protecting consumer rights, ensuring food security, as well as ensuring that business integrity is maintained during this period. So rest assured that we as a commission is here. We are here to help and support even COVID-19 relief efforts and everything, bearing in mind the need to adhere to proper competition principles. In terms of contacting us, we could be contacted through our website. There's a website, we also have our email, the tntftc@gmail.com. We also have active Facebook and LinkedIn pages, and you could generally write to us as well too. So with that, as I come to the end, just to mention, we are committed and will continue to raise awareness of competition. We have done a number of sensitization programs. We actually have been doing a lot of media interactions of late, and we are committed to doing that. We will be undertaking certain market studies in terms of areas that we think are very important. And of course, based on the feedback of stakeholders as well too, we'll also be assisting in compliance documents. And as if indeed an entity wants us to help in that respect, because we understand the need, this is new and the need for there to be compliance. And of course, we'd also offer stakeholder training. We look at this as even a presentation here as an opportunity to train persons and everything. And so with that, I would just like to close though by saying that we are again committed, as the chairman had indicated, to promoting and ensuring a fair marketplace. And this is important because we want Trinidad and Tobago economy to be strong, resilient, and fair. And quite clearly that this legislation, you see some of the potential benefits. Our global competitiveness could improve by having legislation such as this. We understand the need for this legislation to work with important government policy. We're already part of various policies, thematic areas of the government I mentioned earlier. And so this could really be part of long-term sustainable growth and development efforts, because at the end of the day, competition, as you know, has a very important role to play in improving productivity and the growth prospects of Trinidad and Tobago. So with that, I would like to thank everyone for giving me the opportunity to explain the work that we do, how we can be contacted, and of course we have questions that we will try to address now.
Okay, Mr. Narayan Singh, thank you very much for that presentation, which in fact was pretty comprehensive. I have been taking note of some of the questions, and indeed, I see that you have indeed, even without looking at them, touched on and given to some extent some clarification. So what we will now do is turn to the questions that have been raised. Can we, Bevan, Farisha, can we all see the questions that have been raised?
Oh, yes, thank you. Thank you so much, Chair. Yes. So I would begin by some of the questions that are asked. So the first question we have here is, how can the Fair Trading Commission assist micro and small enterprises in the tourism accommodation sector and deal with international corporations who operate in Trinidad and Tobago that facilitate unfair competition in relation to pricing for accommodation?
Okay, could I start, Farisha, with that question? The very first point is, how do you determine unfair competition? And I think that that is at the heart of the matter. We have foreign investors in different forms coming into different sectors of Trinidad and Tobago, and we encourage that. And of course, we will have domestic companies who are competing with these companies in various sectors. In this particular case, I think mention was made of the hotel sector. There are many issues in there. To begin with, in respect of on the side of economists, and then on the side of law. On the side of the economists, it would be, how do we determine whether these prices are not because of the size or scale or scope of the particular enterprise? So this multinational might have access to quite a wide range of resources, both in Trinidad and Tobago and in fact in the world, which allows it to deliver a service at a cheaper price. How does a small hotel in Trinidad and Tobago compete? Well, if we investigate, if a report is made, and if our investigation demonstrates that the price, there is some unfair practice taking place, then there are certain kinds of actions that can be made, that can be done by the TTFTC. And the ED would have mentioned, by law, we can request the kind of information, any kind of information that we may wish to get in order that we determine how the prices are arrived at. But let us assume that we have found that the prices are unfair. Then there are ways in which we deal with that. First, appealing to the particular company that they need to address particular issues, and the act spells those out. But I would go further and say that sometimes in the case of smaller companies, not only in the hotel sector, but across the board, price competition might not be your only way of competing, especially if those prices are fair. You may wish to compete in other ways apart from non-price activity. And in fact, we have seen very successful companies here in Trinidad and Tobago, and indeed globally. And in fact, you can find where non-price competition have in fact been strong enough to in fact take care of prices which are lower, but which smaller companies, more nimble companies, more domestically based companies, more creative companies can hold their end on any market. So that would be my answer, Farisha, to the first question.
Thank you so much, Chair. And I'm seeing here that we have another question. The question states, please clarify if in a merger, the definition of to carry on business in TNT is limited to the physical location of the HQ, which I believe is headquarters in Trinidad and Tobago, as it pertains to the technology-driven services.
Evan?
Well, what I would say is that the legislation is very broadly interpreted, and to be very careful, we have read, and to other persons, and we have had similar questions before. I would say that we have jurisdiction here. The carrying on business doesn't mean you have a physical location here. It means if you're making revenue from in Trinidad and Tobago, if you're paying taxes in Trinidad and Tobago, those kind of things, we would look at a plethora and a variety of things to make such a determination. Now, we've had situations where we have determined whether that this entity is not doing business in Trinidad and Tobago. But indeed, if indeed the example you gave there, Frisha, well, the question, the person asking the question, that would entail doing business in Trinidad and Tobago, even though there is not a physical presence, because sales are taking place in Trinidad and Tobago. But what I would want to stress, I mean, people would recognize that yes, this might be another step in the process, but the fact of the matter is that our role is to also protect and promote business and the interests of consumers as well too. So if entities are doing business in Trinidad and Tobago, we have to ensure that the right entities are also doing in terms of their pricing and in terms of their general behavior. And with respect to mergers, by and large, now I don't want to speak for Trinidad and Tobago, but I'm talking about globally. 90% of mergers are approved once they're received and once all the documents are in order. Because most competition agencies recognize the importance of these types of mergers because of the efficiency considerations and general business considerations, which is even more important now during the COVID pandemic. So that is why I would say is that it would be considered in the view of the commission in terms of the how that section 14 of the act is presently drafted. But at the same time, I will also mention that we are committed to doing what we have all in internal processes in place to ensure that once issues don't raise considerable competition issues and things, we will act as efficiently and effectively as possible to approve if need be.
Okay, thank you so much.
Mhm.
Thank you so much, our Executive Director. I'm seeing here that we have another question.
Sure.
The question states, does the role of the FTC or the provisions of the Fair Trading Act address transparency in supply chains? States like California have passed laws to mandate companies to show that they have inquired into the existence of forced or exploited labor in their supply chain. This will prevent global human trafficking. I saw the person wanted to let you know they saw this information at an earlier web event at the TTIC focused on human trafficking and at the T and TMA.
Edie, if I
Yes.
may make 2 points
Sure.
before you join in the answer to that. And for Richard, I'll just say that there were several questions which came before. The first is that first a complaint must be made to the TTFTC demonstrating or illustrating what exactly the complaint is, where does the problem arise, and so on. And of course, providing some information as to what the case is. Secondly, it is difficult to prejudge what might be necessary, what information we might need. But if after investigation it is discovered that particular bits of information are required from a company, as I have said and as DD has said already, we are entitled by law to demand that information, which will help us clear the particular company or have us ask for further information or ask them to correct some action that is in fact harmful to other businesses or to consumers.
Okay. Yeah. Well, Prisha, to be more direct as well too. With respect to the issue that the person asking the question raised, now directly now we, unless it's this amounts to a violation of the Fair Trading Act, in terms of that in itself, the use of, I mean, I'll give you a global example. I mean, Nike, who has been alleged to have been using the type of labor in certain countries and everything, have not been the subject of an investigation by the Fair Trading Commission based on them using that type of labor. So what I would tell you is that what I would tell in answering, I would indicate that that in itself is not a reason for us to investigate an entity for being guilty of anti-competitive practices, because that in itself is not. However, what we also do, as you would know, is that we also advise the government on competition issues. And this means we have a holistic view in terms of advising, in terms of global competitiveness and things like that. Now, based on these kind of complaints, we could, if indeed it's a sector that we regulate, we could, in our reporting to government, indicate that a market such as this is not competitive locally or for our manufacturers or based on the fact that they cannot become even globally competitive because some of the entities who are importing things into Trinidad and Tobago in that particular sector are using the type of labor that was mentioned. So that is how we could get indirectly involved in these broader societal issues as well too.
Okay, thank you so
But
much.
definitely, that in itself is not a ground for to be anti-competitive for the purposes of the Fair Trading Act.
Okay.
Okay.
Thank you. Yeah.
For Risha, I will just like run through what I'm seeing here.
Chair, thank you.
There are two questions which I'll ask Bevan to answer. The one on landmark cases and the one after that on CARICOM aspirations. In respect of the unlevel playing field initiated by public service activities, is this covered in the Act as well? If I understand the question correctly, it is whether you can have, whether public service activities, commercial activities, that is, where the government is involved, the state enterprise is involved in a commercial activity, whether the Act applies to such enterprise, and the answer is yes. The answer is yes, that is, once it is a commercial entity, they would fall under the Act. The Act does not distinguish between private companies and state-owned enterprises or government-owned enterprises. Bevan, there are two questions just before that, one on landmark cases and the other one on CARICOM aspirations. Right. Could you give some answers, please?
Well, landmark cases. What I would tell persons who want to do their research. Well, we have not brought any actions before court yet. Obviously, we just established and everything. For persons who are willing to do research, I would say to research EU cases, landmark European Court of Justice cases on these issues. As an example, if you want to examine issues such as abuse of dominance, a well-known case is the United Brands case. So just Google United Brands and you will hear how the EU, the Court of Justice there, has addressed that issue. Right? So because abuse of dominance and what is dominant and what you mean by that. So I would suggest that look to the EU. I would have said, given all systems, the UK, but of course, because of the how it was in how that legal system was before Brexit, was that the European Court of Justice was the superior court of record. So basically that would be the jurisdiction, I would say, in terms of landmark cases there. Now, there have been a number of landmark cases by the US Supreme Court, but of course they're legal, and that's been my training actually. But I wouldn't want persons to definitely look at that as the be all and end all about in terms of that, because the jurisdictions are different. So that would be that. They also had there were other landmark cases. Example in the US, the case that was brought against IBM that led to IBM being broken up. Not IBM, sorry. AT&T that was broken up into, they call them the baby bells. That was a result. There was also the case against Microsoft in the 90s in various jurisdictions, where it was found that and you can see the effects in even a jurisdiction like Trinidad and Tobago, where before Internet Explorer used to be and I'm sorry yeah, things like Internet Explorer and were automatically part of of Windows, where Windows came pre-installed in PCs. As you know, that's no longer the case, and that was the result of antitrust cases that were brought around the world, whether it be by the European Commission in the EU or by the Department of Justice and the Federal Trade Commission in the US. So so you actually see that every day as an example of what happened as a result of that no longer do these things come automatically pre-installed in your computer. You have to actually buy a license. So that was an example of how you might see that in everyday activity. What is going on presently, you all may know, is that the EU is launching a case, has indicated, with respect to some of the practices of Amazon, and the US as Department of Justice has launched a case against Google. More precisely, it's related to how Google advertises and how it uses various market spaces and things like that. So, you know, those are some of the things that, in terms of landmark cases, in terms of the CARICOM region, there have been a few, and I would want to point out two cases, if I may. The first one was a case involving Digicel, and why I think that was very important. That went to the Court of Appeal in Jamaica, and again these cases have an effect, as you see, from Trinidad and Tobago as well too. Case in the Digicel case, and obviously I would think a person who was involved in the law would have asked this question. The Digicel case related to the work of the Fair Trading Commission, which in Jamaica at the time also had the function of being a tribunal, where they would make decisions based on evidence before them, and it was found that that was a violation of administrative law, because that commission, especially because of the size, they did not see, there was not a clear demarcation between the staff and the commissioners. This doesn't happen, of course, in a larger jurisdiction. So that was what was found, and basically it meant that in Jamaica that cases would have to go to the courts instead of the commission to make a determination. And that's why, of course, was reflected in the Fair Trading Act now, where the commission here, our commissioners, do not have the functions to impose fines or other penalties. That will have to be done through the courts. So that is something that I think was an important case for the region. And just to reiterate what Chair was saying, with respect to actions against government entities involved in commercial activity, there was a case, and you can see it on their website, there was a case brought against the Barbados Oil Company, National Oil Company, by the Fair Trading Commission. And this was with respect to certain activities that the Barbados National Oil Company was involved directly in. And of course, it meant that there was no exemption, because that entity was involved in commercial activity, even if it was owned by the government. So those are the things I would say from at least some of the landmark things to look at the beginning. But of course, the landmark cases also depends on the kind of areas where that tickles your fancy, so to speak.
Okay, thank you very much, Edie, for that. They are moving quickly along. There are two questions, the answers for which can be found on the website, so I will not take time to do that. Current members of the commission and information on complaints or inquiries. You get that information on the website. If we go further down, we come to a question: is the FTC going to be reactive? And then it touches on resources. I will make 2 points, and on the following question, I would ask the ED to reply. On that particular question, let me say that the Act empowers the FTC to, one, address complaints raised by other businesses, members of the public, so long as it falls within the Act then. And secondly, if there are issues that come to our attention, but have not been necessarily raised by the public, we are entitled to investigate such issues to the extent that they can bring harm to other businesses or to consumers. In respect of the other part of your question, with respect to resources, the Act was only fully proclaimed in February of this year, as I think the ED mentioned, although we have been doing some advocacy and training since 2014. At the present time, I think we can say that we have enough resources for what we have to do. But as demands grow, we expect that there are going to be increased demand for resources, and we expect that we will get the resources to do the kinds of jobs that we are expected to do. I now pass you over to Mr. Narayan Singh. With respect to that question, the cost to businesses to prepare and submit.
Well, the fact of the matter is that given the role of the commission and everything, it is necessary to because of our role as a watchdog for free and fair competition in Trinidad and Tobago, for these to come to our attention. So we will work with entities. Of course, as I've rightfully indicated, we need as much documents as possible. In terms of the threshold generated, again, it's the legislation is clear. 50 million is the threshold in terms of the total assets, and the entity is carrying on business in Trinidad and Tobago. This is how the Act is presently structured. What I would say is, if indeed we are getting an issue such as this is really coming, and we have noticed a lot of this is coming to our attention, it will be raised with the Honorable Minister as well, too, as a part of, because as a part of most entities, there is a review in terms of how these pieces of legislation is operating, and that could be something that we could consider to moving forward. But I would just tell you that the provisions there are not, it's not alien to other jurisdictions. And so in terms of the generation, in terms of the thresholds, in terms of revenue generated, it's really, the question is really the asset valuation. And of course, we have to make sure that the assets exceed $50 million, and the entities intend to do business in Trinidad and Tobago. So if this is indeed a recommendation, I would suggest that it be brought and to the attention of the ministry, because we are acting based on what the legislation says right now, and we are not in a position to make any changes to what is presently there.
Thank you very much, Edie. I wish to thank the anonymous attendee for raising very interesting questions. The next question raised by anonymous attendee has to do with local content. Let me say that local content is not an issue that the Act empowers the FTC to address. I am aware that that is an issue under the Ministry of Energy, and there are certain guidelines in respect of local content and the way in which the Ministry of Energy treats with local content in respect of the energy sector. We are not empowered to demand of companies to increase, reduce, or any such thing. Our issue is clearly one of, is the action harmful to competition? Is the action of a particular company preventing another company unfairly from entering business or not? If so, how? And what measures should we take to prevent anti-competitive businesses and anti-competitive practices? These are all identified in the Act, and really we intend to carry them out.
Okay.
Any further questions? I don't think I see any. There was, I think, one of the first questions, somebody just mentioned NP, but there was no question. So I really don't know what the question was, but I will take the opportunity simply to say government makes policies with respect to divestment, with respect to privatization, whatever. And we saw in the budget that that announcement was made. Since then, we have no further information. Our intention, of course, is to ensure that we do not have the formation of cartels which treat unfairly with the pricing of fuel, with respect to the distribution of gas stations. I think in this role, I would mention a sister organization that is necessary and legislation that is necessary in respect of procurement. We hope that that legislation is going to be with us and is going to help regulate the business environment so that businesses can operate in a market economy, which is what we have been operating, and that the practices encourage companies to be innovative, to compete by all means, by being efficient, by being innovative, by doing the kinds of things that would make us compete and allow us to compete in any part of the world or compete with companies coming in here. There have been defined and there have been recognized practices which are anti-competitive. They are enshrined in the Act, and that is what we are charged with. That responsibility is with us under the Fair Trading Act. Are there any further questions? I'm not seeing any more.
Okay. No further questions.
Yeah, for sure.
Oh, no, Chair. There's no further questions.
Okay. It is now 4 o'clock. And if there are, should we keep it open? Are there, we will not like to keep you beyond 4, but we stand ready to answer any question that you might have. If not, feel free to visit our website, send us your questions. We would respond to them. And it remains then, am I leaving out anything, Edie?
No, Chair. I think it will be very clear. Just to mention that we are here. We are here for the business community. Contact us. We will try to respond to any pertinent questions and issues as soon as possible. As I said, we are accountable and a transparent agency. But for us to work, of course, we need to have a business community that is able and willing to work with us.
So with that, thank you very much, ladies, gentlemen, friends, guests, Trinidadians, foreigners, whoever you are, wherever you are listening to us. Thanks very much for attending our session and for finding out more about the work of the FTC, which is to ensure that we have a growth in business, growth in employment, growth in foreign exchange business, growth all around, and to have a much better and a much better and brighter economy as time goes on. Thank you very much.
Thank you very much.
Thank you.
Okay, so yes. Okay.
Farisha? Bevan?
Yeah, I'm still here. I don't know if you wanna have a conversation after. Or... I think everybody, I don't think the meeting, everybody's still hearing us, I think though.
Yeah.
Yeah. Okay. So could we call back in a while?
Yeah, for
Could
sure.
we-
We could use the same link, for sure.
I will.
No. No. Our own link from our meeting this morning.
Yes, we can.
Remember
We
we had our
can
meeting, our board meeting link.
yes, Edie, we'll do that. I'll give you all a call. Okay,
Yeah,
thank you so much, everyone.
Okay, take
Okay.
care all. Bye.
Okay.
Thanks so much.
Bye. Thanks
Bye.
very much.
No problem.
Yeah.